Hi, thanks for visiting worklawyer.ca. As the commute around the Greater Toronto Area becomes more and more time-consuming and in turn more expensive, more employees are taking advantage of the opportunity to work remotely, and among those, many have the added benefit of being able to work from home. In some cases, the ability to work from home is explicitly set out in the terms of the employment agreement. However, quite often, this kind of working arrangement is simply the result of a verbal agreement between the employer and the employee. How would you feel if you had the benefit of being able to work from your home office for many years, only to have your employer turn around and say that you now had to work from the head office? As an employment lawyer, the question that comes to mind is whether or not this constitutes a fundamental change to the terms of employment and, in turn, a constructive dismissal. This is a question that the Ontario Superior Court of Justice tackled in a decision called Hagholm and Correa Incorporated. In this decision, the employee worked for 22 years with the defendant employer and its predecessor, working 3 days from home and 2 days at the head office. Not long after the employer informed the employee that she could no longer work from home and instead had to work from the home office, the employee resigned and she later sued for constructive dismissal. Although there were other factors involved in the determination of this case, one of the major considerations was the removal of the ability to work from home. In considering the evidence, the court noted the following considerations. First, the employee would have to drive the very busy Highway 401 in both directions. Second, the traffic volumes on Highway 401 would add roughly 3 hours to the employee's commute each day. Third, with the large volume of car and truck traffic and the speed that those vehicles traveled, the highway would be a very dangerous place to spend a significant amount of time on. Fourth, the employee would incur a significant cost in operating a vehicle 220 kilometers each day. The court noted that the facts of the case were not seriously in dispute by the parties. This permitted the court to make a finding that the ability to work from home for 22 years was a fundamental or essential term of employment. The court went on to conclude that the employer had breached this fundamental term of employment and thereby constructively dismissed the employee. For employers, one takeaway from this case is that it is important to confirm in writing that the ability to work from home may be subject to change and would not be considered a constructive dismissal. For employees, it's important to note that the ability to work from home can be an essential term of employment that cannot be easily changed without providing the employee with adequate notice or pay in lieu thereof. I hope you enjoyed this video. For more information on this and other employment-related topics, please visit worklawyer.ca. Thanks for watching.